Great. My name's Ashley, and the topic of this panel is risk assessment, which I think this audience probably understands is quite a broad one. It's a very hot topic in prosecution and in criminal justice reform right now. But this panel is going to focus specifically on the use of actuarial or statistically derived risk and needs assessment tools that are increasingly being used in many jurisdictions to assess a defendant's risk to reoffend and to identify treatment interventions that may reduce that risk. And because this is the Innovations in Prosecution Summit, we're also focused mainly on the potential benefits and challenges of these tools as they relate to the prosecutorial function. For this topic, we're fortunate to have an excellent group of panelists who have thought deeply about this issue and have really led efforts to include risk assessment as a dynamic component of a meaningful reform agenda. I think we're going to just start off with Professor Mason kind of giving a sense of what we're talking about with this specific topic area and the issues at stake here.
Great. Okay, I'll sit down and talk into the microphone. Thank you for having me. It's an honor to be here. My task, as I understand it, is to present a brief overview of criminal justice risk assessment and areas for attention. I apologize if I'm telling you things you already know, but I'll try and make it as quick and succinct as possible. So criminal justice risk assessment, what do we mean by that term? We mean the actuarial assessment or the statistical assessment of the likelihood of some future event. And in the criminal justice context, it's often future arrest. In the pretrial context, it's sometimes failure to appear. So it's the statistical assessment of the likelihood of some future event under status quo conditions, assuming no intervention. There are fundamentally two different kinds of risk assessment tools in current use in the criminal justice system. I think of the first as checklist instruments, and the way these are developed is a group of statisticians or a statistician looks at a bunch of past data and posits a series of individual characteristics that are likely to correlate with the particular event of concern. Then uses statistical analysis to test for correlations, identifies the factors that correlate most closely. Those factors become the risk factors, and you develop an instrument on the basis of those factors where for each factor that applies in an individual case, the person gets a certain number of points, you add up the points, you get a risk score. So here's an example. These are the risk factors for the public safety assessment, which is currently the most common tool in use in the pretrial context. I should have said recently there's been dramatic uptake in actuarial risk assessment for purposes of pretrial detention and release decisions, as well as in sentencing. But risk assessment has application and is being implemented at every stage in criminal proceedings. So these are the PSA risk factors. The PSA assesses the likelihood of 3 events: failure to appear, FTA, new criminal activity, which is actually any rearrest, and new violent criminal activity, rearrest for a violent crime. And here's the weighting. You can see you get a different number of points depending on each factor that applies for each scale. Here are some other examples. This is the Indiana risk assessment tool for pretrial decision-making, the IRIS-PAT. It has only 7 factors. A person who manually checks off the ones that apply, adds up the score. You get a final risk score that places you into a risk class at the bottom, low, moderate, or high. And here's my effort to distill a bunch of pretrial risk assessment tools and the various factors that they entail. And the other kind of risk assessment tool, which is the vanguard, is a machine-learned algorithm. And the way you develop a machine-learned algorithm is dump a whole bunch of data into a computer and let the computer itself find the correlations with no a priori commitments about what factors are likely to correlate. So the machine finds the correlations among factors or combinations of factors, and it itself builds the algorithm, which is likely to be much more complicated than a checklist model. So far as I know, there are only a very few people and places using machine-learned algorithms at the moment. Happy to talk more about that later if you want. Here's my checklist of areas for particular attention and concern with respect to risk assessment. Risk assessment overall really has tremendous potential to bring uniformity, to improve the accuracy, and to some extent to improve the transparency of the risk assessments that criminal justice system actors are already doing subjectively. But it also generates a lot of concern and controversy. And I think stakeholders who are either implementing or considering implementing risk assessment tools should think about each of these arenas. Purpose. First of all, risk assessment tools themselves are procedural tools. They don't necessarily promote any particular substantive goal. A tool is just a tool. So there is always this fundamental question: to what end is the system using a risk assessment tool? What is the objective, and how is the system going to ensure that the tool is deployed in service of that objective? Recent research, including a paper by our former Quattrone Center colleague Megan Stevenson, has demonstrated in the pretrial context, the bail reform movement has generated a lot of interest around risk assessment. Risk assessment tools themselves don't necessarily have decarceral effect. They don't necessarily lead to a decrease in pretrial detention rates. That fact has generated widespread concern among civil rights advocates. 120 civil rights groups recently published a shared statement of civil rights concerns about pretrial risk assessment tools, in fact, calling for the abolition of the tools. In my view, that's a bridge too far. That's not the answer. But it is important to recognize the difference between a procedural tool and a substantive objective. Secondly, with respect to purpose, there are a series of policy judgments that go into the design and implementation of any risk assessment tool. I'm not going to talk in depth about them now, but it's important to understand that they exist and that you have to make them. So they include what is the particular risk we're going to assess. As I mentioned, a lot of tools assess the risk of arrest for anything at all, including for very trivial offenses or violations of probation or parole. It's not obvious to me that that risk is particularly relevant. And I've urged stakeholders to give more thought to how we delineate the risk that the tools will assess. There are a series of other important normative decisions to be made. Also happy to talk more about that later if it's useful. Perhaps the most important decision is how the system's going to respond to the risk assessments that the tool produces. The tool itself doesn't tell you what to do. It just analyzes the risk of some event. In the pretrial context, the public safety assessment, it's the Arnold Foundation that has developed and is promulgating this tool, and the standard model for implementation is that the jurisdiction implementing the tool develops a decision-making framework, and this is one example, which guides courts with respect to what decision to make on the basis of the tool's assessment. It includes this matrix where the boxes in green represent people who score low on the failure to appear and the new criminal activity score, and this matrix recommends release with no conditions. For moderate risk people, it recommends release with some conditions. For high risk people, it recommends maximum conditions. All right, so this framework does not recommend detention at all on the basis of a risk assessment tool. That is best practice. A risk assessment itself should never be sufficient grounds to detain. But the decision about who falls into the low risk categories, where you draw the lines between those categories, and then what the recommendations are for each risk category are stakeholder decisions, not decisions the tool can make for you. So that's purpose. Accuracy, it's essential to be clear about what the tools do, what information they produce. There is sometimes a misconception that risk assessment tools predict binary outcomes. This person either will or will not have some outcome, and that, for the most part, is not the case. The tools, what it means if a person is classified as high risk is that this person shares traits with a group of people who, if they are grouped according to those shared traits, will have a higher rate of the event you're worried about than people outside the group. What that rate is, the tools don't necessarily say. It may be lower than you'd expect, and in fact, the rates vary tremendously among the tools and across jurisdictions. So what this chart shows is for a series of pretrial risk assessment tools, the particular event they're measuring, over what period, and then for the highest risk group, so the people who were designated as high risk, what the rate of that event was. And as you can see, the rate of any new arrest ranges from 10 to 42%. Only 2 of the tools in this group assess the likelihood of arrest for violent crime, and for those tools, the rate of that event among the highest risk group was around 8%. In my view, it's really important that stakeholders understand what these rates are, and that they hear them as well as or instead of the evaluative labels of high risk and low risk, because what's a high risk to you may not be a high risk to someone else, and this is important information. Transparency is the third item on this list. I'm not going to talk about it a lot. There's been a lot of discussion of transparency and risk assessment. It is important. It's important that the tools be transparent, that people understand the basis on which they're being classified as high or low risk, and that they be able to contest their score if there's an error in the data. If they aren't, there are potential due process concerns. But in my view, this is not the primary obstacle in risk assessment. Most of the tools are actually quite transparent, and those that aren't can be made more so. Efforts are underway. So it's an important value to have in mind, but I don't think it is ultimately the biggest challenge. Equality, on the other hand, is a real challenge. There has been a lot of concern that risk assessment tools produce racially disparate results. And this article in 2016 galvanized that concern. This is an article published by ProPublica called Machine Bias. There's software used across the country to predict future criminals, and it's biased against blacks. ProPublica had analyzed a bunch of data from Broward County, Florida, found that the risk assessment tool in use there, the Compass, had dramatically disparate effect on the black defendants in the data sample. And it has generated a tremendous amount of concern about risk assessment tools and resistance to risk assessment tools. What became clear, though, in the aftermath of this article is that the cause of the disparate impact was not a mathematical flaw in the model or a distortion in the algorithm. It was the difference in the base rate of the thing the tool was measuring, which was rearrest, among the black defendants and the white defendants in this data set. And so here's my little self-plug. I have a new article about this that you could read for more information. But the core point of that article, what I think is the core point for everyone, should be the core point for everyone engaged in this debate, is that there is a problem with racial inequality and risk assessment. We should all be concerned about it. But the source of the problem is not actuarial methodology per se. The source of the problem is the nature of prediction. All prediction, whether it's subjective or actuarial, looks to the past to make projections about the future. It looks at patterns in the past and interprets them as projections for the future. And in a racially stratified, unequal world, if the very thing that we are assessing the statistical likelihood of, if that something like arrest has happened more frequently to communities of color in the past, any method of prediction, whether it's subjective or algorithmic, checklist, machine learned, is going to have a disparate racial impact. You can't solve that problem by fiddling with the algorithm or regulating the input variables or even rejecting actuarial methods. What I've urged in my scholarship the only way to really mitigate the disparate racial impact of risk assessment is to fundamentally rethink how we understand and respond to risk itself. If the response to risk were, when possible, supportive rather than coercive, if we did what Ken was talking about in New Orleans and what others in this summit have talked about, if the system, when possible, strove to address the causes of the risk with support rather than throwing people in jail, that would mitigate the disparate racial impact of risk assessment. Of course, I understand that's not always possible and there are resource constraints. The last 2 points on my little agenda here, implementation and accountability over time, I'm not going to talk about at length. Implementation is the real battle, and my co-panelists are the people who understand that battle. So that's, you can talk about risk assessment theory all you want, none of it means anything, everything changes on the ground. And accountability over time is a challenge, but also a necessity. As these systems are implemented, there ought to be procedures in place to ensure auditing over time to ensure that the tools are having the desired effect and to monitor disparate racial impact. It'll be difficult to do, but it's no less necessary.
Thank you very much, Professor Mason. I think that is a really great segue to the implementers. So I actually would like to start with John Chisholm, the District Attorney for Milwaukee County. Thanks.
Sure, thank you. Yeah, so something that I'm going to address is going to sound familiar because you've heard different aspects of it from our previous speakers. I actually came to the risk assessment field from a completely different perspective, and that is back in 2006, we had the opportunity to invite the Vera Institute in to Milwaukee County to assess racial disparity. Many of you might have seen or remembered Mark Maurer's sentencing project work from right around then, 2005, 2006, and it was coming out. It had identified Wisconsin as having the highest disparity rate of incarceration in the United States. Well, obviously, that was of concern, particularly to the practitioners in Milwaukee County, since the vast majority of the African American population in the state of Wisconsin is in Milwaukee. The question arose then, why is that? Was there anything that was happening in terms of the practices of the Milwaukee County DA's office that were contributing to that disparity? So we invite Vera in to come in and take a look at our charging practices, and sure enough, what do we find? You find that in certain almost predictable categories, there was some significant disparity. The good news was that overall, our charging practices were pretty even-handed, but there was widespread disparity in things like the lower level drug offenses, the public order offenses, things of that nature. So the next question then became, what do we do about it? How do we actually address that? And from my perspective, the advantage, again, and this correlates with the discussion we had earlier, it was actually sitting down with the public defender's office, the defense bar, sitting down with people in the community that wanted just to have a voice in how we address these problems. And prior to that time, there really was no mechanism for us to have these discussions of how we systemically change that process. We created a Community Justice Council in 2007. And started looking for ways of creating mechanisms to have alternatives. Now, it's been an iterative process, I'll tell you, but one of the first things we collectively decided, and I say that I really think it's critically important. This was not a decision I just made on my own. Okay, we're gonna develop a diversion program. We're gonna do deferred prosecutions, and for our highest risk, we're gonna put them into a full-blown drug treatment court. This was a process that we developed together with input from all the stakeholders. We had to go to the county board and ask them to invest several $1 million to create pretrial services to allow us to screen everybody that comes into the Milwaukee County jail system. So we call it universal screening, everybody. It doesn't matter what you're coming in for. You're given a screening for both risk and for need. It required the public defenders and our office to change what we did, change the structure of our offices. I had to put experienced prosecutors in at the front end of the system, matched with experienced public defenders so that they would have the ability to talk within hours of a person being arrested, that person being screened. We're providing them with all the discovery right, again, as soon as we're getting it basically, and letting them do that critical thing that they need to do, which is, as was mentioned earlier, do you even have a case here? Because if you don't have a case, then we're not gonna do this mechanism. If there is a case here, then the next question is, what's the best thing? What's the best path to take for this particular defendant? Again, with the express goal of making sure that we do everything we can so that they don't come back into the system again. That's what eventually led us to seeking out and getting the risk tools. It was an organizing principle more than anything else. It allowed us to identify the people in a way that wasn't dependent on our anecdotal experience. In other words, it wasn't just prosecutors saying, this case is always worth $5,000 cash bail, this one's worth PR, this one's worth $10,000 cash bail. That's really how the system had operated, or because it's a certain type of offense, we're going to recommend this kind of a procedure going forward. So when I say it was an organizing principle, it was just that. I will also acknowledge up front that I pay close attention to the criticisms associated with risk assessment tools. I do not believe that they're the be-all, end-all. Again, I think that they're a valuable tool. That's exactly how I look at it. They're just a tool. It's just one other piece of information that prosecutors should be looking at in addition to consulting with their colleagues, the public defenders, the defense attorneys, talking to the victims, talking to the pretrial service specialist, and just thinking through. There also, in my view, has to be that connection to the community. So one of the advantages I also have is that we have a community prosecution unit. So I have prosecutors, in geographic areas often where the highest rates of crime are occurring, and they're able to actually give our prosecutors information on the people that are coming in, that we're considering for alternatives or diversions or things like that. So again, it's not simply, I've never considered the risk assessment tools to be the be-all, end-all. It informs our discretion, but it doesn't define our discretion.
Thank you. And Justin Bingham is the city attorney for Spokane, Washington.
Spokane came to the risk assessment arena through the MacArthur Safety Justice Challenge. Both Milwaukee and Spokane are jurisdictions that received a large sum of money from the MacArthur Foundation to rethink how we use our local jails. And one of our key strategies was the implementation of a risk tool. I know that Philadelphia is in the midst of doing just that as part of their work, the Safety Justice Challenge. Many of the sites are looking to try to move from the subjective to the objective, to look at data and not look at, hopefully, bias. Changing from our old ways of doing things to looking at different and more objective viewpoints is a culture shift. We talked about people that wear robes. Well, let's be honest, judges, they do have a lot of power, but they also have a lot of ego sometimes. And having someone or something tell them how they should make a ruling is sometimes a difficult thing to understand or to accept. We believed when we started the implementation of a risk tool that it would simply be the judges that would cause us pushback. Well, we were wrong. It wasn't the implementation with our judges that was a problem. It was the implementation with literally everyone. We are a case study in what not to do in implementing a risk tool. Dave and Nitin have actually seen my presentation before, and as Nitin said during lunch, I loved your presentation. It had so much self-deprecating humor because you literally just have to laugh at yourself. We built a risk tool. We did exactly what Professor Mason was saying, we had a checklist. A researcher from WSU took our data and tried to find those most predictive factors, built a tool based upon those factors, and we then attempted to implement said tool. The problem was that while our factors were predictive, the practicalities of implementing the tool caused it to fall on its face. Things like how the information was presented to judges, how it got to the prosecutor and the defense. Literally at one point, we were failing because we had put together a tool that was very color-based, yet the courts didn't have an ability to print the information in color. So the judges were getting these pieces of paper, and they just couldn't figure out where exactly on the continuum the risk tools were falling. And so those cut points become very important, except they can't tell where on the cut points they are. Additionally, I think we, as many other jurisdictions, did not actually understand or put enough importance on the word tool. We felt as though the risk tools would be the be-all, end-all, that they would, in fact, these tools would give us our answer. And of course, that was what the judges were most concerned about. They want to make the call, and that's their right and their obligation. But the tool was a tool, and we were trying to use it as an answer. And that's a big problem, and that's one of the reasons that our effort failed. Tools are not a panacea. They are not what you need to make everything work right, but what they can do is inform your decision making, to try to pull out that implicit bias that happens in subjective decision making on bail and release, because that's really what the tools are designed to do. When we were in our prep for this, in our call, I used the term garbage in, garbage out when talking about bias, and Sandy was, yeah, that's exactly right. I had no idea that our article's actually entitled Bias In, Bias Out. But that's the big question when you're really talking about these tools that we now understand that maybe we didn't a couple of years ago, that while the tools are going to give us scores, they're going to give us information based upon historical criminal data, I think we're now just realizing that when we're putting in junk because of over-policing, we're getting out junk, and those same biases that we were trying to get rid of by taking away the subjective choices of judges, we're just putting right back in a different form. So we have to be more thoughtful. We have to be more, I think, realistic in what risk tools can give us and what they can't. Ultimately, in Spokane, we decided that we needed a complete reboot, that it wasn't probably the best choice to build the tool out on our own. We are transitioning to the PSA, the Arnold tool. But I think this implementation is going to go much smoother because we know what we're getting. We understand what problems we had in our implementation. And I think now everyone is on sort of that same wavelength of where we need to go and what is required of all the different actors. It's a paradigm shift in criminal justice. It's a needed paradigm shift. But the one thing that I would leave you with my remarks here is that whatever the tool says, do not fool yourself. The decision to release or not release is a political decision. It is a decision by judges, prosecutors, appointed public defenders. It is a decision by people in the system, how we build release matrix, how we build our decision-making tree. We still have a very important role to play in this, regardless of the algorithmic ideas that we put into the system. It's us as humans. We have to make these calls, and we all have to be on the same wavelength. And you know, if I actually, looking back at all of this, I would say that where we failed the most was not setting that out from the beginning. Understanding that what is high risk, medium risk, and low risk, and where does that sort of point where release happens, supervision happens, and detention happens. So it goes beyond the tools. I think successful risk tool implementation is very broad, and it can't just simply be choosing your tool, figuring out how accurate it is, what is the area under the curve when you're trying to decide how accurate you want to be, what's your variance or your concurrence rate with decisions. It's really, who do you want to release? What is your tolerance for risk? And how do you make supervision happen instead of incarceration?
All right, thank you. So actually, I kind of want to go off a point that you just mentioned, just the kind of the garbage in, garbage out idea, because that was kind of a motif of our discussion earlier. And one thing that I find very interesting about your experience, John, is that you started the reforms in your office in 2006, but you implemented an actuarial instrument later. Right? And it was in response to some issues you were seeing with the program. So it'd be great to hear it sounds like your experience was different in that way, kind of. So I think it would be great to hear kind of at what point you brought in the actuarial tool. And actually I'd like to also kind of touch on the accountability over time issue, because there is this other issue with that, what data is going into the tool. And that's kind of the ongoing assessment and collection of data and evaluation. And so if you could just talk about your experience, that'd be great.
Sure. So the irony of all of this is that I basically made a commitment. So we start the Community Justice Council in 2007. Milwaukee County has no early interventions program. It has no drug treatment court program. We had tried one back in 1999, and it was based on it was the worst model in the world. It basically said that for 17, 18, 19-year-old young men that were caught dealing crack cocaine, we'd put them into a drug treatment program. And as you might imagine, there was about a 90% failure rate, right? And I was a felony drug prosecutor at the time, and I just remember these conversations out in the hallway. I'd tell the defense attorney, hey, I think your guy's eligible for this diversion program or alternative program at the time, and I'd hear the defense attorney say, that's great news, take it to his client, and I could literally hear his client yelling at him, telling him that I'm not addicted to crack cocaine, I sell it, I don't use it. And so it was just absurd, right? But that really became the institutional framework within the system. All forms of problem-solving court were then looked upon as just being a joke. Right? You talk to any judge, you talk to any prosecutor, and they just summarily rejected anything that had to do with trying to do things differently. We've tried that before, it didn't work. So in 2007, when I started approaching this concept again, and the concept in the construct of trying to reduce the racial disparities coming out of Milwaukee County, that forced me to start looking at what were other people doing and what was going to be successful. But my first decision was to go to the chief judge and say, look, I want a drug treatment court. I don't know how we're going to get it. She said, well, the only way you're going to get it is if you can reduce the equivalent of one of our felony drug courts. We had 3 of them. We had 4 of them at the time. If I could reduce one of them, that she would consider converting that into a drug treatment court. I said, okay. So I just, internally, we just started doing our own diversions on the lower level drug offenses, right? Didn't really have any risk assessment, but from my standpoint, I knew that wasn't optimal either. I didn't, there should be a way of differentiating between the people that are coming in and making sure that we're identifying the people that really are riskier and those who are sort of the first time into the system. And so that took me on that path right there, and eventually we were able to build this out. But I can't overstate the importance of doing it in a collaborative way with our partners in the community as well. I mean, again, the people that ultimately made the system that we have right now were Deputy DA of mine who's in charge of general crimes and one of the deputy public defenders who literally just became married for the last 10 years. It's almost like they fight with each other all the time when it comes to, for example, setting up what categories of offenses go into what box. They're constantly readjusting them, saying, we're looking at the data. That's been another frustrating aspect of it, is to actually develop a pretrial services database that actually evaluates the effectiveness of our systems. That's been frustratingly slow, but that's online now, so we can actually see whether or not we're staying within our aspirational goals. And for the most part, it's been really, really helpful. We have about an 80% success rate for our outright diversions. Comes down to about 65, 70 for the deferred prosecution, sometimes called deferred judgments. And then for the highest risk category, yeah, we're struggling in that 35 to 40% success rate, but that's okay. I mean, back in 2006, that would not have been okay to me. I would have been scared to death by that kind of a success rate. I'm okay with it now. I get it. I mean, I just fundamentally get that, look, the highest risk people are going to, by definition, struggle with this, but it's, in my view, worth it to give them that opportunity, along with a host of other changes. The final thing I'd say is that it starts, one of the questions that came up in the other panel is why aren't prosecutors required to know behavioral science and neurological science? Well, the fact is because that's not how we train people in the criminal justice system. The concept of evidence is very narrow. But my aspiration would be that we do that we really perceive ourselves as being part of a public health system, and that the public health system sees themselves as being part of the public safety system. One advantage of this approach, I would say, though, is that it starts baking into assistant DAs the concept that external evidence, external partners are critical to our success. And I would like, we're trying to implement a trauma tool. So we'd like to be able to assess both victims and offenders as they're coming in, and assess them for their exposure to trauma, and put that on some kind of a scale that we could then use to inform our decisions. It's allowed us, for example, in the domestic violence world, nobody would ever divert anybody on a domestic violence case. Well, we've started diverting hundreds of domestic violence cases because we have a place to put them, and we can put them in some trauma-informed cognitive behavioral therapy interventions now. And again, they've shown tremendous success. So again, to me, it's just a process of changing the way we think about what kind of information we consider important when we make our decisions. There's always going to be the classic, the role for sort of the classic prosecution. It's a serious violent offense, and it's got to follow that traditional route. But I think just going through this process has made the people in the system better informed about a lot of other issues.
Thank you.
And we have seen the disparities go down, by the way, as we've had that measured as well. We have seen the racial disparities significantly impacted. Is it directly because of all of these? I don't know that. All I can say is that since we've implemented this process, we've seen racial disparities go down, particularly when we compare it with other counties in the state.
And I recall, I think you mentioned that kind of reducing racial disparity was your original goal kind of at the start out, right?
That's exactly right.
Yeah. And I have just one question. I'd like to get to audience questions next, but just one more question that's really for all of you. I think Sandra kind of brought out the issue that there is a lot of kind of debate on this issue, and we talked about how it seems like people are talking past each other in this debate. And I was wondering if there is kind of one aspect of the public debate that you think just kind of gets it fundamentally wrong, or that you would just you wish you could kind of address or start at first principles with. I mean, that's a big question, so you can answer it however you would like, but just kind of an area where you think just kind of it'd be great if we kind of started out on the same page in a way.
I would just reiterate what I think has been a theme of the panel, and that Justin put so well, as was also in my slide presentation. Risk assessment tools are just a tool. They're a procedural tool. They themselves are neither the source of substantive solutions nor the source of the substantive problems. They're a procedural mechanism that can help with the process we use to fix substantive problems and attain substantive goals. But a lot of criticism and a lot of hopes have been pinned on what, to me, it's not either the solution or the problem.
Yeah, I think that's exactly right. That a lot of people, when risk tools became sort of the new hip thing to do in criminal justice reform, it really was I think the assumption was that this is the way we fix the ills of pretrial. This is how we get more people out of jail. We put the right people in jail, and all will be right with the world. Well, that's not exactly how it works. The risk tools are only as good as how they are not only implemented, but how they're designed, the questions that they ask. This is one of the main struggles we had with our researcher on how we designed the tools, coming up with what were the right questions to ask. We had two questions that, as we dived into the tool, because our tool went way beyond our bail statute, and that was one of the main problems. We need to look at risk as defined by your bail statute. In Washington State, two things hold you in jail: failure to appear, your failure to appear rate, are you going to show up for court, and are you likely to commit a violent crime? Well, our risk tool looked at property crimes, it looked at drug crimes, it looked at violent crimes, and the judges had just a list of different possibilities, probabilities. They're going to do all these things, and so it sort of muddied the waters. So our researcher was trying to be innovative and have a tool that looked at every factor. Well, at the end of the day, our bail statute only allows a judge to look at two things, and the other stuff sort of is just, helpful. So figuring out what you ask and where it's appropriate, very helpful as you start implementing.
So the last point I'd make is it may seem way off topic, but it isn't to me. I don't know how many of you have read Richard Rothstein's Color of Law. Look, I've increasingly just come to believe that some of the biases that are reflected in incarceration rates, arrest rates, in predictive tools and everything like that is all because of decisions that were made to concentrate the most disadvantaged people in our society in very specific geospatial locations for long periods of time, and then deny them access to a host of resources that other parts of our society were given. So that seems like a big leap, but it really isn't a leap to me anymore. When you see, again, through the work of social scientists and others that can really start mapping out in great detail where the most acute problems in our communities come from, and they're also closely clustered together, and they have been that way for 30 to 40 years. And those are the individuals that we're asked to intervene in on a regular basis. That's where the police are asked to go. That's where the problems occur. And so I would argue that part of the concerns about bias that come out of tools are also baked into decisions that the criminal justice system has been asked to deal with on its own for 30 to 40 years. And until we fully understand that and start reversing that and fulfilling the last great unfulfilled promise of the civil rights movement, which is that we get people into safe, affordable housing and give them access to generate wealth and take care of their families, that we're going to be doing a lot of the same things over and over again.
Thank you. So I have a few questions from the audience. The first one I'd like to ask is there a sense that elected judges are a key stumbling block? And is there data about appointed judges? I think.
I don't. I've wondered this myself and have heard the question raised in other fora, and to my knowledge, there's no data about whether concurrence rates.
I don't think New Jersey is the key state right now as far as using the risk assessment statewide. They're all appointed judges. They have no elected judges there.
In our jurisdiction, it didn't really matter if it was an appointed court commissioner or a judge that was doing it. Our concurrence rates were very similar. I don't think we dived into that too deeply. But we did notice the concurrence rates varied by court, which was interesting. And my court was actually the worst. And it was bizarre because what I was told by pretrial services was that our judges were more likely to hold people when the tools said to release, and they were more likely to release when the tools said to hold. And they couldn't figure out why it was our court, who in our court and the city of Spokane, we have just a cafeteria style of programs that we do. We have courts for everything. And we have been known as being very progressive in our sort of view of criminal justice, yet my court's the one that really made no logical sense in how they use the tool. So again, go figure.
I would suspect it's a matter of culture more than anything else. Megan Stevenson's project in Kentucky found that concurrence rates varied not as between appointed and elected judges, but as between rural and urban counties. And I don't have the explanation, but I wonder if it's a cultural phenomenon.
Yeah, it's what Justin said about the risk issue, is the community willing to exercise that risk? And many times your prosecutors, defense bar, and judges are consistent with their community. And so New Jersey being that example, the urban areas, a lot more releases. The more suburban became that, well, we really want to do that. And when you err, what do you err? You err the person going in. So it is, how far are you ready to go? And acknowledging there's a risk, right? Yes. It's a tool.
The next question is about a recent op-ed by Michelle Alexander. I'm not sure if you read it, about electronic monitoring. So in the New York Times, Michelle Alexander is a new columnist for the Times, and she wrote a piece where she described kind of the rise of pretrial release, in part based on risk assessment, but release with some kind of monitoring device, something on the rise, and as a kind of a new thing to be concerned about. I believe that gloss is kind of okay. Yeah, and so I think this person just kind of wants to know if you think this is an issue. I believe in that article she also mentions for-profit companies being an issue related to this, although that might not be a new thing. Yeah. So.
Well, it's a difficult thing. I think that having the option of releasing people on monitoring is better than not releasing them. So let's just start there. Can it be abused, and can it also be misused? Certainly. I don't think you can fundamentally address these issues until you get cash out of the system completely. So Wisconsin is still a cash bail system. So our risk assessments are paired to some extent with whether we recommend cash bail or not. In the ideal world, that you would not, you'd have certain categories of people that would be perfectly appropriate for just outright release. You'd have individuals that would be best for them and for everyone else if they had some form of monitoring while they're out. And then there's probably, this is the most difficult thing, I think, particularly from the defense side, there are probably individuals that should not be released on bail at all. And since that's not what our laws and our Constitution allow, at least not in a prima facie way, that's the difficult thing. So there are systems that, of course, have preventative detention. It's written into our statute, but it's almost unworkable in Wisconsin. If we do a preventative detention hearing, you have to start the trial within 60 days. It triggers a mechanism that's saying that you have to then start the trial within 60 days. So it's never been used, and it's not used. So I think the broader discussion is whether we could create systems that take cash out of it completely, so that we're not using proxies for what we really consider to be risk, and we're talking more honestly about people that we really don't think should be back out in the community while the case is being adjudicated.
I think that Michelle's piece really talks about the sort of the things we should be aware of and be afraid of that we're going to accidentally bake into this new system. That if our hope is that the bail system will become more fair, we're going to accidentally build in barriers, whether it be financial, your ability to get electronic monitoring, or it be substantial, that you have states moving to statutes that really are preventative detention statutes. So buyer beware, I think, is what she's saying in the article, that this isn't just, we aren't to the end of this road, and that we should really be concerned about how people may implement things. I know that a lot of people are very concerned at SB 10 in California, and what that's going to lead to. Is it actually better or worse than what they have? So it's important, but I don't believe we should lose sight that this is still progress, that we are talking about actually putting the right people in jails based upon actually objective factors and not based upon subjective decision-making of people that may or may not be biased.
Okay, yeah, all right. No, I think it's a great question. In medicine, we use risk assessments to route patients to professionals with specific expertise in dealing with the issues they present. Have you ever considered using information from risk assessment tools to make decisions about which prosecutors are assigned to certain cases? Could risk assessments enable better specialization, individualization, and matching professionals to problems in prosecution, as it has in healthcare? And I guess it's for the prosecutors.
Yeah, sure. I think that's a great question. And yes, in an ideal world, so as part of our contribution to the MacArthur Project, what we focused on was just sort of an explicit statement that we wanted to keep the mentally ill out of our jail completely, period. We just wanted to do that. And I think that's one way of the assessment process, not necessarily the risk assessment per se, but just the overall assessment. In my view, the very best system in the world would be, first of all, having police officers with access to the kind of process that we're talking about here, where they encounter individuals and they themselves know that they have an array of people that they could directly take individuals to, and that the problem would be solved right at that level there. That's not the world we live in right now, so generally the police response, even though we're working on obviously great programs like LEAD and others, are trying to inculcate that culture, but right now the vast majority of the systems have some kind of a police intervention and followed by an assessment. I think that, again, I would love to have a world where behavioral health specialists and defense attorneys and prosecutors and victims and defendants themselves can make decisions, and the victims can make decisions on what directions, what levers of the system are pulled. And the assessment process, whether it's risk assessment or evaluations of people's mental and physical health, I think increasingly in the future we're going to see that.
I would say one of the things we need to be concerned about or just be aware of when you're looking at risk assessment tools is the information that's gleaned from these assessments and where that's used. It's one of the things we've been dealing with in Washington State. Our Supreme Court provided an ethics opinion recently that essentially says that if court personnel are pulling information that is dynamic in nature, not things simply from criminal history or public available databases, but they are pulling dynamic factors from people, from interviews, they are themselves acting on behalf of the judge, which then makes it an ex parte communication and problematic. And so they threw that out there as we are trying to go through a statewide task force to build out what does our pretrial reform look like. So it's a little bit of a curveball, but it's something we need to be concerned about, because what do we do with all this information that goes into the tools? Because there's a lot of information that's not just pulled from criminal justice databases. There's a lot of information that requires an in-person interview, and a lot of the tools that we saw on the list, they require a lot of information gathering. And so, you know, I like the idea that you can sort of match. Well, that works great in John's world because his office is really focused on good results for all parties. I don't know if that's the case in every office around the country, so perhaps it could be used for ill, I don't know. But it's something that we are dealing with, is how do we even use tools based upon how the data is pulled, because our court says you shouldn't be doing that.
Great, and I think it looks like we're into break time. Thank you all for a lovely panel, and you can come up to them.